first off, actually, now that you've mentioned these MDL cases, is it a class action lawsuit that we're looking at here against Citadel? Because that's how I've seen it described. But now I'm not sure if that's been poorly worded. Now that you've mentioned that there's a difference between these two types of like multi plaintiff cases.
Right. So in this, what happened was there were two, but this was up to the lawyers. They're the ones who decided how to file this. So basically, it was filed. There are currently two complaints. One is an antitrust complaint, and the antitrust complaint is against Robinhood, Citadel, and all the other brokerages that were involved in the short squeeze litigation that, from what took place in January. Mm-hmm. In regards to the limitations and the taking away of the buy button. That was filed as an MDL.
Okay.
That is filed as a multi-district litigation, which is the preferable, in my opinion, methodology. There was another complaint that was filed against just Robinhood for negligence, gross negligence, breach of fiduciary duty, and a number of other counts. And that was filed as a class action. Now, that's a litigation strategy. That was up to the lawyers. I'm not going to second guess why they did that. But me as a lawyer, I think that the clients benefit the most through MDL litigation. Because like I said, it's more case specific, and you have a class action is all or nothing. If that main case is dismissed, it's dismissed against everybody. Now, in the MDL, this initial motion to dismiss is to dismiss the initial complaint. And right now, there's only 4 or 5 plaintiffs named in that complaint. If they survive this motion to dismiss, then a bunch of other people can then start. They'll have what's called a form. It's like a form summons. It'll just be available to download, the lawyers, and they'll be able to fill it out, and they'll be able to send it to their clients. So basically, the MDL structure is different, like I said, than the class action structure. But yeah, so there's two. So that's the difference. One's MDL and one is class action.
So the one I'm most interested in is the antitrust suit. That's the one that I feel has I don't know. I feel like that's more significant in this case, just because of what it's alleging. So, on what grounds have they filed an antitrust lawsuit here? Like, what is the basis of their case?
Okay, so basically, it's only one count in the plaintiff's complaint, and it's a violation of the Sherman Act. So the Sherman Act basically says the legal. I mean, if you read the actual Sherman Act itself, it's this ridiculously worded statute. It basically says, though, in layman's terms, that there's a conspiracy that unreasonably restrains trade. So, do you want me to break down like what each of those things mean?
Yeah, please.
All right, so a conspiracy, that's the first part, right? So what's a conspiracy? The word conspiracy gets thrown around on the internet so much, and it was funny, Citadel was calling all the plaintiffs' lawyers conspiracy theorists, which made me laugh because, people on the internet, they might be saying, wait, they're calling us conspiracy theorists, but they're being alleged to have committed a conspiracy. So what's the difference between the two? I think the term conspiracy is used so loosely nowadays to describe anybody's opinion you disagree with that, I think when people hear the word conspiracy in the lawsuit, there might be some confusion. So conspiracy is an actual legal cause of action, right? And a conspiracy involves an agreement. There has to be an agreement, right? There has to be an agreement between one or more people. These people get together, and it happens most commonly in price fixing situations, right? So basically, two people that own a business get together, and they basically say, listen, I've got an idea. We can do this where we can, fix the prices and eliminate our competitors. And what do you think? You think we should do it? And the other guy says, yeah, let's do it. And then that limits trade, that restricts the ability for there to be a free, free market economics. And that is the very basic explanation of what a conspiracy is. It's an agreement between two people to basically, screw somebody else, for lack of a better word. But that's the layman. That's not a legal term of art. That's the layman term. I mean, that's basically it in a nutshell. Yeah. I apologize if your show's PG.
No, it's not. Don't worry.
Yeah. Okay. But yeah, so that's basically what a conspiracy is, and that's what they, are alleging as in their complaint.
Okay, right. Before we go further, I'm just gonna pause you there because there's some mad thing happening outside. I'm just gonna shut the window here very, very, very quickly.
Oh, sure. No problem.
It's always the way, you'll start a stream and a conversation and there'll have been no noise until you actually begin recording or streaming, and then everyone decides it's party time.
Of course. I was just dealing with the same thing. One of my kids came in here tiptoeing, but the tiptoeing was like blub 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 thud 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 thud. It's like, they're trying to be quiet, but they actually wind up being more noisy than they intended.
Yeah. I mean, that's also the other issue. So, so the allegation here that we're discussing in this antitrust suit is that there has been conspiracy to limit and restrict trading. So, do you know what the legal definition is here? Do you know what the legalese is for it? What they're attempting to suggest is ridiculous? What the thing that they're trying to say they definitely didn't do is?
Well, the legalese is that conspiracy to commit, X, Y, and Z price fixing. I mean, that's the legalese. What's going on here is this. Okay, so here's the allegations in a nutshell, right? Robinhood took away the buy button, right? They said you're not allowed to buy AMC, you're not allowed to buy GME, you're not allowed to buy COS, you're not allowed to buy a number of ticker symbols. And their allegation is, their defense, I should say, is, well, we had a $3 billion, amount of money that we had to pay. We couldn't do it. So we had no choice but to do this. But the plaintiff's allegation is, that's not really what happened. What happened was this. You and Citadel conspired to take money away from retail investors. Okay, so the defense argument is that's not plausible, because under the most controlling case, which is Bell Atlantic versus Twombly, that's the leading Supreme Court case. That case basically said, if you're going to allege a conspiracy, you have to show that it was plausible, that there's that your theory of conspiracy is more plausible than their explanation for why they did what they did. So Robinhood is saying, listen, we didn't do this because of any nefarious scheme. We did this because our backs were against the wall. So this is a plausible explanation for why we did what we did. Plaintiffs say, not so fast. It's not a plausible explanation because, Robinhood, this is not the first time something like this has ever happened. Companies have short squeezed, there's been short squeezes before. There's been volatility in markets before. And you can't say, oh, well, we weren't aware, we didn't have enough money in the accounts. That's our bad. We didn't mean for that to happen. Their argument is, no, that's not what happened. What happened was Citadel and you got together. This was happening. And Citadel basically said, this is allegation. Nothing's been proven. Citadel basically said, Robinhood, listen, we have a ton of short positions. This is killing us. Can you do us a favor? Yeah. Let's take away the buy button. Yes, we understand it's going to make you look like you have egg on your face and you're probably going to lose a bunch of customers. But the reality is, and as alleged in the complaint, we're paying you millions and millions of dollars a year in PFOF. So if you lose us, if we lose all of our money and we go belly up, who's going to pay you? We're your biggest influx of cash. We know you have other companies, other companies that will pay you, but we're the biggest fish in the pond. We're your golden goose. So if you lose us, you're going to lose everything, basically. So that's the allegation, that they were all there. There was an agreement, and they were all in on it together. And they basically said, "Listen, you scratch my back, I'll scratch yours. If you want things to keep going the way they are, then you're gonna make this happen."
Good. Yeah, so that's basically that's it in a nutshell. It's like really well summed up. So there's a few things that I wanna note here is that first of all, to suggest that Robinhood would be not under pressure for this is to suggest that there isn't a lot of their revenue coming from payment for order flow. So first off, they had in 2020, 75% of their payment for order flow came from 75% of their revenue came from payment for order flow, and 81% of their revenue in the first 3 months to March 2021 came for payment for order flow. That's $331 million, an increase of 91 million from the same period the previous year. So this is not an insignificant amount of money that has been that they're talking about here. It's not something that is inconsequential, shall we say, to their business model. So the other thing that I want to note is that the allegation that Robinhood have made is that they were forced, because I've listened to the explanations in the hearing and what Vlad Tenev had said to Elon Musk when they did like a clubhouse together. So essentially they got the call in the middle of the night, or they got an email at like 3 o'clock in the morning, and they said, "Hey, you have to post this extra 3 billion or you can't trade." Basically, we're not going to support you as a broker through our clearinghouse. So the NSCC, they then negotiated down to 1.4 billion, not 0.7 billion, so $700 million. And then Robinhood were like, okay, we can afford that. That's not the same size as like the market capitalization of our entire company. We can afford to pay that. And they said that they had negotiated with the NSCC that said they would decide to restrict the buying of some stocks and shares to reduce their exposure to massive volatility, because that was the reason that the VAR requirement, like by the NSCC, was $3 billion. It was worked out on their formula, and it came in at $3 billion. And then the thing that is really interesting to me is like the key to this case is that the DTCC, the head of the DTCC, has said that they waived the NSCC had waived all capital requirements from that day through to the end of that week. So it seems to me at least like someone is lying. Thanks for making it all the way to the end of the video. Don't forget to like, share, subscribe, and leave a comment for us in the comments below. Let me know what you thought and if you'd like to see more of this from the show. Thank you, and we'll see you again next time.